Thank you. We will start. Thank you very much and welcome to all participants to this webinar about international business law. My name is Alejandro Zubimendi, Academic Secretary of the Escuela de Práctica Jurídica, and I will be hosting and moderating this session. This session is intended to be an introduction to the coming program about international business law starting on October 21. The International Business Law Program and this taster session is part of a broader collaboration between the University of Law and the Escuela de Práctica Jurídica of the Universidad Complutense de Madrid. This collaboration is intended to offer an integral approach to the international law from a common law perspective and from different fields such as corporate law, commercial law, new tech law, or international tax law. I'm very pleased to introduce the panelists of this session. First of all, Jim Moser has been practicing during many years in commercial real estate law for several law firms in the UK. Jim has been also lecturer in the University of Edinburgh and the University of Glasgow, among others. Currently, Jim is the director of the professional development programs of the University of Law. Rory Collins has many years of experience in practicing tax law in several law firms in the UK. Particularly, he is specialized in corporate tax issues. Currently, at the University of Law, Rory is senior tutor in tax matter for the professional development programs. And lastly, the last panelist, Claire Lawrence, has many years of experience in M&A, corporate finance, and corporate governance, practicing in several law firms as a legal counsel. And currently at the University of Law, Claire is associate professor where she teaches commercial and M&A law at the professional development programs. Lastly, questions will be answered at the end of the sessions. So please feel free to use the chat box during the session in order the arising questions to be answered at the end of the session. So again, thank you very much to everybody for attending to this interesting session, and I hope it will be really useful and interesting for you. So I give the word to Jim Moser. Thank you.
Thank you. Thank you very much, Alejandro. Hello, everybody, and thanks very much, as Alejandro said, for joining us this afternoon or this evening, as it may be. As introduced, I'm Jim Moser. I'm Director of Professional Development at the University of Law. In that role, my job is to deliver programs to more or less everybody who's working in a legal firm or a legal business, or as a lawyer within a corporation. So our clients are trainee solicitors, apprentice solicitors, qualified solicitors, partners, corporate counsel, etc., in that kind of area. So I'm going to give you a brief introduction to the university and to the program, and then pass you to my colleagues, Rory and Claire, who will take you through part of the program that we will be delivering during the course of this year. So Rory, could you pass me on to the next slide?
Yes, if I, that's it. There we go.
Thank you very much. The university is an interesting organization. As you can see, it started in 1876, and it started actually as an organization to deliver lessons to legal businesses. So in that sense, as a university, it has not grown as an academic university teaching students of law from the beginning, but almost backwards from the profession, from the legal profession, into a student teaching university. And that's very important because it explains a lot in our origin, our culture, and our approach to legal law teaching. We operate at the moment in 17 locations globally. We are mainly in England in 15 locations, but we also have operations in Berlin and Hong Kong, and we're expanding all the time. So there will be a further operation abroad in the Far East very soon, and we continue to expand our locations elsewhere in the UK, and we have recently opened in Scotland, which is where I'm speaking to you from just now. We've started an operation in Glasgow. So constantly expanding, doing the same kind of work, as I say, in my area, which is teaching qualified lawyers and others working in legal businesses. We, of course, nowadays, have a huge commitment to teaching undergraduate students, master's students, postgraduate students, and students coming through who are going to enter the qualified legal profession. As a result of that, and the fact we've been going as long as we have, we now have 71,000 alumni, at least, in a network, both in the UK, but also internationally. And we're in touch with them regularly to teach them further courses. For instance, at the moment, we are delivering a program in China. We are delivering a program, or will be delivering this program in Spain. We have recently delivered programs in a number of other international countries, as well as the substantial work we do in the UK. Rory, thank you. We very much have a student or client-focused ethos. So that could be considered most succinctly as we are there to teach. We're there to make sure that people who attend our legal learning, whatever that may be, that they actually learn what is being delivered. And that's very important because some of you may know that certain legal training doesn't achieve that. So it's very important to us that that happens. To achieve that, all of our people, including Rory, Claire, and myself, are qualified solicitors or barristers or judges in the UK. So that gives us, and have practiced in some way within the legal industry, legal profession, as well as being excellent teachers. And that's one of our unique selling points that allows us to achieve the ethos of focusing on our clients and students and teaching them well. We use innovative and contemporary techniques. So a lot of our work, yes, there is lecturing, but there is also interactive work. That's the majority of what we do in any session, and you will find that out if you're going through the stream we'll be delivering in Spain. And that interactivity we consider extremely important to ensure that, again, our ethos of learning is achieved. One of the reasons we can do this well is we have very strong connections in the legal and business industries in the UK and elsewhere, allowing us to be contemporary, allowing us to be in line with the most up-to-date techniques within law firms, and being very much aware of what's happening in the legal industry in the UK or elsewhere to ensure that we are totally ahead and up to date with what is required. We're very business-minded and flexible in our approach. This is very necessary, both to, given the field we teach in, but also to make sure we can deliver the best to our clients. We have access and support from the Global University Systems Group, which we're a member of, and that is a very worldwide organization. Rory, the next slide, please. You can see some of our alumni and what they have done, particularly in the left-hand corner there. You can see Sadiq Khan, who's currently a very important person in the UK in that he is the Mayor of London, and as such a leader both politically and socially in the UK. and I'm pleased to say he is one of our alumni, and you can see some of the others who have studied with us. Clearly, as one of the major providers of legal education in the UK, leading to qualification as a solicitor, a number of extremely important lawyers have passed through the University of Law over the years and continue to do so. We also have very important diversity strategies, ensuring that the people who come to the university come from all backgrounds and enter all sorts of the parts of the profession in studying with us. Rory, thank you. Turning to the program, in association with our hosts, we have put together 4 streams for you, which were considered very important that people entering this program should study. And what Claire and Rory will be doing is taking you through the first of those streams, or the highlights of the first of those streams, which is international business law. And I'll leave that to Claire and Rory to explain in more detail when they come to it. Each of the streams, as you'll be hearing from Rory, I believe, will involve an introductory or 2 introductory sessions, which largely give you a background to English legal system and to English legal structuring, which we consider is necessary to understand the rest of the program, which deals more with black letter law, the black letter law subjects you can see listed there. So, for instance, if you decide to study the international business law section, you will have 2 sessions dealing with general business system, legal system, and legal structuring in England and Wales. If you then choose to go on and do another program, you will be able to do a shorter version of that, missing out those 2 sessions, which are introduced at the beginning of every one of the streams. So again, if you opt just to buy international tax, you will again have the opportunity of doing structuring and English legal system at the beginning. The 4 streams, as you can see, are international business law, which involves large corporate parts, international tax, which quite obviously involves taxation, new technologies, which involves key aspects that are very present in the legal industry, such as artificial intelligence, what may be the role of blockchain in the future, and other innovative technologies. And the last one, commercial law, which deals with very practical applications of law, particularly in a commercial legal environment in a law firm today. One of the sessions, for instance, is how the financing of a law firm might work in a classic UK commercial context. I understand from Alejandro that you have a strong interest if you're attending this course, and there's been quite a lot of interest in comparative law, so looking at how civil law might work in these areas, say in a country like Spain, as compared with how the common law deals with the same subjects in England and Wales. That's an area I've been involved in myself in my career, as I come from a civil law oblique common law country, which Scotland is. And these are very interesting things to study, and you will get the full opportunity to do so as part of these streams. The goal of what now follows is to give you a strong idea not only of the subject matter that will be covered in the first stream, but also the kind of teaching that you might benefit from if you decide to sign up for any one of the streams. So I'm now going to pass on to Rory to take you through the first bits of stream 1. Thank you, Rory.
Okay, well, thank you, Scotland. You passed the baton on to me from Northern Ireland. Everybody's going to have to wait a little bit longer to hear somebody speaking the Queen's English. The only one of us who actually has grown up in England, I think, is Claire. So hopefully neither Jim nor I are incomprehensible. You'll all be able to make us out. Okay, the stream 1 deals with international business law, and I will be taking the first 2 sessions, and the sessions run on a weekly basis. So the first 2 sessions I'll be taking will be English legal system, UK and US legal industry, organization, main players and structuring. And then Claire will take the next 2 sessions, and then we're going to get other colleagues in to take you for the last two sessions, sessions 5 and 6, and we'll explain that as we go through this. In addition, you'll also have the pleasure of my company for the international tax course, which I believe is running at the start of the next year. So I'll be taking that as well as sessions 1 and 2 on all 4 streams. Okay, well, let me just briefly outline what I hope to cover in the English legal system, which I'll be looking at on the 21st of October. And really, I appreciate that you all come from a civil law jurisdiction. I'll really be looking initially at what the common law is in England and Wales, what equity is, and what the rule of law is in England and Wales. And to do that, I will take you through a court judgment, the case of Donoghue and Stevenson, which actually is the very first case that all lawyers study when they go to university. And it's really quite an interesting case because it is the basis for negligence in England and Wales. And the facts of it, as I will explain in a couple of weeks' time, are really quite peculiar and unique because, just to give you a flavour of it, it involved a lady up in Scotland who drank a bottle of ginger beer which had been bought for her by a colleague. And she drank this bottle of ginger beer, and lo and behold, out toppled a decomposed snail. And not surprisingly, she was rather upset by this, and she sought to sue under negligence. But at the time, there were great problems in suing under negligence, and the courts had to formulate a new remedy for this particular plaintiff claimant. And the case itself, as I say, is the starting point for the law of negligence. And we will see how the judges have expanded that particular case and brought it up to date with other streams of negligence, and how they have rationalized that case and used that case to justify their decisions in later cases. We will also look at the hierarchy of courts, and the hierarchy of courts is really central to the common law system because the higher courts in England and Wales define what the common law is, which the other courts below them have to follow. So we'll look at how the courts are structured in the UK. We'll also look at how Parliament passes laws and courts interpret those laws. And this is really quite important because it goes to the core of the British Constitution, because at the core of the British Constitution is this concept of parliamentary sovereignty, that Parliament is sovereign and it can pass laws on any subject matter that it likes. And in order to explain the nuances of parliamentary sovereignty, what I propose to do is to use Brexit, something which is still topical almost 5 years later, use Brexit as a case study to show how the courts have reconstituted and considered parliamentary sovereignty, that initially it was perceived that the English courts were bound by EU law, and now, having possibly liberated themselves from the EU structures, the parliamentary sovereignty has been reinstated. I'll also look in this course at something which might be of terrific relevance to you, namely how to become a solicitor in England and Wales. And this has been a matter of great flux in England and Wales over the past couple of years, to the extent that there's a new process brought in from the start of this month, 1st of September, for people wanting to qualify as a solicitor. And it's much more liberal and much more, the whole ethos behind it is that it should become easier to become a solicitor in order to diversify the profession, something that Jim mentioned earlier on. And we will also draw on analogies from America, looking at how you might become a lawyer in America, and also looking at the issue of parliamentary sovereignty in America and the role of the US Constitution, which limits the legislative authority in Congress. We'll look at that. There's a case of Marbury and Madison from 1803, which puts limits on legislative authority in America. And as the final point in this session, what I want to do is just to examine and give you a brief overview of the civil law procedure and the criminal process, and perhaps draw on comparisons with how the UK has an adversarial process and the continent, Spain as well, have a more inquisitorial approach in order to determine issues under civil litigation and in criminal actions against individuals. So that's really what I want to explore in the first session in 2 weeks' time, okay? And then in the following week, what I want to look at is the legal structures and the structures which underpin the legal profession in England and Wales. Because England and Wales actually has quite a liberal sense of how legal services can be provided. There only are a number of restricted legal activities which can only be provided by members of various professions, of which the solicitor's profession is just one. So I want to explore how legal services are provided in England and Wales and how the solicitor's profession is actually regulated. Yeah. What are the main institutions that solicitors come across in their professional lives? So we will look at the role of the Solicitors Regulation Authority, which, if you like, is the licensing authority for solicitors. If you want to practice as a solicitor in England and Wales, you have to be a member of the SRA. So we'll look at the function of the SRA, and we'll also look at the role of the Law Society, which, to put broadly, the Law Society is the professional association for solicitors in England and Wales. And also within the SRA strictures, we will look at issues such as the Solicitors Disciplinary Tribunal, the Legal Ombudsman, and the Compensation Fund. And then what I want to do and spend a bit of time doing is to look at the codes of conduct. And the codes of conduct, of which there are two, there's a code of conduct for solicitors and a code of conduct for firms, regulates how solicitors interact amongst themselves and with third parties, and how they conduct themselves. And I'm going to go through some provisions of the codes and explain how they work in England and Wales. So what I propose to do is to look at some of the key points, such as confidentiality, how confidentiality impacts on a solicitor through the codes of conduct, the conflict of interest provisions, and something which is actually pretty unique to solicitors in England and Wales, the concept of an undertaking. The concept of an undertaking in England and Wales is that a solicitor's word should be their bond. And if they don't follow through with what they say they're going to do, that has the potential to constitute professional misconduct on the part of the solicitor. And also I will look at various client care provisions under the codes of conduct as well. Fortunately, you'll be delighted to hear that the codes of conduct themselves are remarkably short, so they're only 14 pages long in total for England and Wales. But we will look at some of the key points within them. And then something else that I want to do is something which perhaps lay people in England don't fully appreciate, is the distinction between solicitors and barristers. Because in England, we have a split profession of solicitors and barristers. And solicitors, on the whole, are the legal advisors who interact with clients, whereas barristers are those people who, you might have seen them on television programs, they appear in a gown and with a wig. They do a lot of court work. So I just want to explain perhaps what are some of the substantive differences between solicitors and barristers in England and Wales. And on that note, can I pass the baton to Claire?
Thanks, Rory. Yeah, hello, good afternoon or good evening, as Jim said, depending on where everybody is. Yes, I'm Claire Lawrence, and I'm part of the team here with Rory and Jim. As Alejandro mentioned at the start of this session, my principal area of practice and now principal area of training for learning and development is corporate law, which is why I have come to join the session this afternoon to talk about sessions 3 and 4 in particular on this first stream of international business law. Rory has just spoken to you about what he will be looking at in sessions 1 and 2. And then for the rest of this stream for international business law, we wanted to have the opportunity to look at corporate transactions here in the UK. So sessions 3 and 4 very much do that, and that's what we'll be looking at in those sessions, because what the focus of those 2 sessions will be is on the mergers and acquisitions of private companies, so limited companies that take place under English law. And picking up on some points that Jim had made earlier and Rory has just mentioned, it will give us an opportunity, I think, to really look at transactions that you may be familiar with in your own jurisdiction, but to look at those specifically under an English law perspective, and in particular how English contract law and how English company law may differ from the work that you're undertaking yourselves. So you'll see on the screen there, we've got session 3, which is the 3rd session of this first stream and which will be running on the 4th of November. It's titled Structuring Acquisitions and Due Diligence. And if Rory just moves on to a slide, I can perhaps tell you a little bit about what we want to cover on that slide. So there are a number of objectives for this session 3. And in particular, what we really want the opportunity to explore is to look at the different types of acquisitions for private company M&A here in the UK, and in particular, the key issues to be considered on an acquisition that is governed by English law. And I think at this point, it's really important for me to sort of flag, in case you're not already aware, that actually there is no legal definition of an acquisition under English law. An acquisition can describe a wide variety of transactions. And so, as I've just mentioned, this session will give us an opportunity to explore that. Whether it's a commercial sale between 2 unconnected parties, whether it's looking at an acquisition that is taking place as a result of a group reorganization, or a sale in an insolvency situation, or even a disposal into a joint venture. All of these ideas will be picked up in this session on structuring acquisitions. You may be very familiar with transactions within your own jurisdiction, but what we will have the opportunity to do on this course is to look at the circumstances, as it says there in that second point, in which for an English law transaction, an asset purchase or a share purchase might be more appropriate here in the UK. Because in the UK, there are 2 principal methods of acquisition, either acquiring the assets of a business, so an asset purchase there, or acquiring the entity that owns that business, a share purchase. So whilst that is very much for the parties to negotiate between themselves and decide, what we can do in this session is look at, on a UK transaction, the factors that the parties will take into account, whether they be commercial, whether they be legal and complexity issues, and also just touch very slightly on some of the tax issues. In addition to those structuring issues, we'd also really like to have the opportunity to show you the overview of a process of an acquisition here in the UK and under English law, and also talk a little bit about the key documentation that you would expect to see. And I'll come back to that a little bit in a minute. Of great importance, and hence the fact we've included it in the name of the session, is due diligence on transactions here in the UK. You may already be aware, but under English law, we have something called caveat emptor, and that means let the buyer beware. So it's absolutely crucial on English law transactions that buyers understand what it is they are acquiring, because with no other adjustments or provisions in place, buyers will be taking all of the risks and all of the liabilities. So due diligence is absolutely key on English law transactions. And therefore, what we'll spend some time in this session doing is looking at just the purpose and importance of due diligence and why that will be important for buyers to understand what it is they're acquiring and how they can best protect themselves. But we'll also look at the scope of due diligence, planning due diligence, and the process itself. And as it says there at the bottom of the slide, just look at some of the key liability issues that are relevant to that due diligence process under English law. If a buyer finds out about something during the due diligence process, what does that mean for it on a UK transaction? Will it still be able to bring a claim? So that's very much what we want to look at in that session. And each of these sessions are 2 hours long. And if Rory just moves us on to the next slide, what perhaps the next slide will do is allow us to see where that structuring leads to in terms of a transaction overview. Because of course, each transaction is different, but generally speaking, an English law transaction will follow a sort of fairly standard format. And what we've done is we've just shown you this slide here today, which forms part of our materials in our session, but just to give you that overview, that transaction overview. So what we can do is talk about those preliminary agreements, as I've just mentioned, talk about due diligence and how that leads on to the negotiation of the acquisition agreement, and also look at what happens at exchange and completion or signing and closing of a UK deal, and whether they need to be separate or whether signing and closing can happen simultaneously. And what is absolutely key on UK transactions, and that you can see there in that signing part of the slide, is the documentation, and in particular, the acquisition agreement. And so whilst in session 3, we'll look at structuring acquisitions and the due diligence process, it's that acquisition agreement that we want to focus on in session 4. And if Rory kindly moves us on through the slides, you'll see session 4 of the course is titled Share Purchase Agreements. And that's a session that's going to run on the 11th of November. And as far as share purchases are concerned here in the UK, the share purchase agreement is often the most significant document in the acquisition of private company shares. Hence the fact we've dedicated a whole session to it on this stream. It's the main contractual document. And whilst it doesn't transfer title to the shares, a stock transfer form will do that, it will set out the contractual terms between the buyer and the seller and really help with that sort of reallocation of risk that I just highlighted when it comes to due diligence. So in this session, and as you'll see from the slide there, the objectives, it will be an opportunity for us to talk you through the key operative clauses in an English share purchase agreement, looking at whether any conditions will be required, and in particular, how those conditions might be drafted and negotiated if you're going to have a non-simultaneous signing and closing. And also to look at those contractual protections that buyers will commonly seek in an English share purchase agreement to protect themselves from these risks that they potentially can be inheriting. In particular, the warranties and indemnities, and also how that can then translate into particular inheriting any tax risks and the use of tax warranties and a tax deed there. That share purchase agreement will have a fairly sort of standard form on English law transactions. And we'll also want to talk to you about the purpose of restrictive covenants and the common use of them on English law M&A deals for private companies. And also to spend a little bit of time looking at the share purchase agreement, and in particular, the main legal issues that relate to something that we call boilerplate clauses. And by boilerplate clauses, we're talking about those terms in an agreement that you may be very familiar with from your own jurisdiction, that we tend to see at the back of all English contracts. Provisions on assignment, provisions on confidentiality, provisions on things sort of like governing law and jurisdiction. So if Rory just moves us on to the next slide, what really we hope that session 4 will be an opportunity to do is to focus on the documentation, that key document that we see on private company share acquisitions here in the UK. It will be an opportunity for us to review a UK market share purchase agreement with you, and also to give you a comprehensive review of what a share purchase agreement looks like here and how that may differ from your own jurisdiction. And hopefully that will enable you to have a discussion afterwards of transactions and market practice for the acquisition of shares when governed by English law, and to pick up on some of those differences between English common law and how it impacts our contracts, and in particular how that may be different from your own jurisdiction. Because that document that we're talking about here on this slide is generally drafted by the buyer's solicitors, and we'll look at the terms that they might put in and how sellers will seek to resist some of those terms. So as I said, sessions 3 and 4 very much focusing on private company M&A. Each of those 2 sessions that I'll be with you for the 4th and 11th of November will be 2-hour sessions. And then following those 2 sessions, there will be session 5 and session 6, which, as Rory mentioned, will be delivered by 2 colleagues of ours to continue the idea of corporate transactions here in the UK. So I'm going to hand back to Rory now to talk you through session 5, and then in a minute I'll just come back to talk a little more about session 6. So Rory, back to you.
Thank you, Claire. Yes, my colleague, our colleague Alexis will take session 5, which is Introduction to IPOs, Initial Public Offerings, flotations of companies whereby they go from being private companies to being publicly traded companies. And there are going to be a number of main themes that Alexis will explore. The first theme is why companies might seek an IPO. It might seem a somewhat naive question, but the basic point is that a company, when it does seek a flotation on a market in London, be it the main market or on AIM, the alternative investment market, which is the more junior market, there is a whole raft of financial disclosure that the company has to pursue. And that is both costly and bureaucratic for the company. And the alternative to an IPO, whereby shareholders of the company might seek to realize value from their shareholding, is through a trade sale, which Claire will be going through with you. And with a trade sale, the formula, as Claire says, is that it's very much caveat emptor. It's up to the buyer to negotiate their protection. Whereas with an IPO, it is very much the onus on the company which is going through that process to satisfy the necessary disclosure requirements, which are either required pursuant to the prospectus regulation rules or pursuant to the AIM rules if the company is going on AIM. Alexis will also talk you through the whole IPO process, the way that it meshes together, because in the UK, we have the FCA, the Financial Conduct Authority, as the main regulator of the main market. But in addition to seeking in addition to actually getting FCA approval for the IPO, the company has to satisfy the London Stock Exchange's admissions and disclosure standards rules. So it's a twin process that an IPO company has to go through. It has to seek approval from the FCA and also seek approval from the London Stock Exchange. And this intermeshing of regulators and the regulatory framework is a key element with IPOs, because it's something that lawyers will have to take into account in drafting the main disclosure document, which with a listing on the main market, that will be the prospectus. With a listing on AIM, it will be an admissions document. But Post-IPO, there's a whole raft of continuing obligations which is imposed on the company in order to maintain the actual market in the shares. So Alexis will explain the UK market abuse regulations, the UK disclosure rules, all of which have to be satisfied going forward, which imposes more cost and more bureaucracy on the listed company. Interestingly, at the moment, there is a bit of a boon in IPOs on the London markets. There is a bit of a resurgence of IPOs and public company work in London. And then also Alexis will go forward and explain secondary issuances of shares and the main types and differences. So he'll analyze with you what a rights issue is, what an open offer is, what a vendor placing is, and when each of those is preferable and when the most appropriate time for a company to use one of those secondary issues is. And now can I just pass the baton finally back to Claire.
Thanks, Rory. I'm just going to very, very briefly talk about this last session in this stream, which is session 6, which is international aspects of corporate transactions, which is going to be delivered by a colleague of ours, Chris Beanland. Chris Beanland is also a qualified solicitor here in England and Wales and is an associate professor in our professional development team. Obviously, this sits hopefully very nicely into the idea of international business law and looking at corporate transactions in this stream. And if Rory just moves the slide on there, I can perhaps show you a little bit about what Chris will talk about in this session. Chris is going to look at why a cross-border acquisition, and particularly when they come about, and in particular, if it is a transaction that's being driven from here in the UK, how that might then operate in terms of things like umbrella agreements, bringing in the transactions across borders. Looking at obstacles to overcome in connection with the transaction. And in particular, I think Chris here will spend some time looking at the differences under English law and perhaps in comparison with civil law jurisdictions when it comes to things like preliminary agreements, in particular heads of agreement, heads of terms, and also the idea of things like duties of good faith, which of course we don't have that overriding duty of good faith here under English law. He'll touch on an overview of legal and tax structures on cross-border transactions and international corporate transactions, and also looking at regulatory issues, perhaps with some reference to competition law. And also, of course, is absolutely key if we're looking at corporate transactions is how those transactions are brought together. By finishing off this stream, looking at signing and closing requirements and how they may differ. I had mentioned to you in my sessions that we'll be looking at documentation, and Chris can then spend a little bit of time looking at how those transactions are actually signed and closed. We've certainly seen here in the UK over the last 18 months, in part, I think, because of COVID, the increased use of electronic signatures and how social distancing and remote working has impacted signing and closing requirements and formalities here in the UK. And it will be interesting, I think, for Chris to explore that at the end of this session. So those are the six sessions that form this first stream on international business law, and I know we wanted to take you through it. I'm now going to hand you back to Jim and Alejandro to sort of round up the session, and hopefully we've left some time for questions as well. So back to you both.
Thank you very much, Claire. You've now seen the outline of the first stream, and basically each of the streams will follow a similar kind of structure. The other three being launched in the new year. So it's the corporate one that you've just been led through that will start very, very soon and continue throughout the rest of 2021. Alejandro, do you want to bring questions into the room?
Thank you very much to all, Rory, Claire, and Jim. It has been a really interesting session. I think you have covered all the main issues arising particularly common law systems. And a brief thought, I think this program, all the programs about the UK system, it should be a really great chance to get closer to the common law issues, and a really great chance to get legal skills to become a global lawyer. So nowadays it's really important not only knowing your legal system, but also knowing another legal systems, and to be able to manage the interaction between different legislations, because globalization pushes us to really challenges to manage the legal issues in multinational firms, and advising in international issues. And just a little question, as I was wondering, I like how important is, for example, in an agreement between a common law company and a civil law company, how important is to determine, to decide where should be the court deciding any issue that could be arise, and any litigation could be arising between different companies belonging to different legal systems, because maybe a company could be interested in set the court in charge for an eventual issue in a civil law country and the other in a common law country. And this is a question I was wondering.
Sorry, was that a question directed at me?
Well, it's a question of who wants to answer that. So how do we decide the difference in two different jurisdictions in a corporate agreement?
Yes, the jurisdiction, how important is to define an agreement between two different companies, how important it is to set the jurisdiction to judge future problems between the parties in the agreement, to fix the jurisdiction in one of another country, taking in account that one belongs to a civil law country and the other to a common law country.
Well, certainly from an M&A perspective, it will be for the parties to agree between themselves what the governing law of that contract will be, and then where any disputes are to be determined. So, for example, on the course that I am looking at, we would be looking at transactions that are governed by English law, but of course the parties to those agreements do not have to be based in the UK.
And in execution terms, Claire, what would you do?
Well, as far as execution is concerned, we would be looking at two issues. One is authority to enter into the agreement. And then the second point would be the law surrounding execution. As far as execution is concerned for documents governed by English law, we do have the Overseas Companies Regulations, which is a piece of law here in England. And what that really does is asks us to go back to the law, the domestic law of the party entering into the contract, and that will dictate or determine what is required as far as execution is concerned. Of course, that is also different to the point about who has the authority to commit that party to the transaction. And as far as authority is concerned, we would look back again to the law of the country of that party. And that's certainly as far as M&A is concerned, which is where often we will be using legal opinions from counsel in that territory or that jurisdiction.
Okay, thank you, Claire. Anyway, I invite you all participants to make any question they consider to be interesting for all. So if you have the participants any question to make, please feel free to chat in the box, in the chat box of the Zoom session. So let's wait a couple of minutes.
Okay.
So I want to.
There we are. There's a question.
I think that might be directed at me. Good evening. I'm wondering how the classes will be divided between UK and US law. Clearly, both UK and US are common law jurisdictions, and the principles underlying the common law are similar for both countries. US is somewhat complicated by the fact that there are obviously 50 jurisdictions there. 49 of them are in fact common law. Louisiana in the far south is a civil law jurisdiction. I will be pointing out comparisons between UK and US law. For example, how to qualify as an attorney in the US, what needs to be satisfied there compared to in the UK. I'll also be looking at parliamentary sovereignty as understood in the UK, how it translates into America with their constitution, for example. But clearly a lot of it is going to be based on UK law in that way. But the principles underlying the common law can be transferable to the American jurisdictions.
Thank you, Jim.
I hope that is assistance.
Is a dog?
I don't know what that dog was asking, but I don't know the answer.
The dog was dormant under my feet. He's just woken up. Apologies.
So another question, maybe it would be interesting for the participant. What kind of practical how will be the practical classes? I mean, I guess the classes will cover theoretic materials and practical issues regarding some structures or some special practical issues about how to redact a contract or anything anything practical you interesting for the participants in the program.
Claire?
I think certainly on my session 3 and 4, as Jim mentioned at the start of this, our ethos is very much, we are practitioners. We are not currently sort of in practice, but we have all been practitioners and now we teach. So the intention is that these are very practical sessions. So whilst, for example, on session 4, we will be looking at share purchase agreements. And of course, that is fundamentally a contract. So we will touch on some English contract law. We will do that very much in the context of that document. So it will be very much looking at the standard provisions of that document, what we would expect buyers to ask for, what we would expect sellers to then want to either resist or agree to. So I think the intention is to be very practical. Certainly, you know, as far as that session is concerned, we want to look very much at the clauses we would find in those documents and to share as much as we can in the time that we've got about market practice here in the UK. And I think just to pick up that question that's come up in the chat box about from the sort of for the M&A perspective, will it cover just the UK jurisdiction, or is there also looking at it from a broader perspective? I think certainly sessions 3 and 4 are there from a UK perspective in terms of English law and spending time looking at how transactions that are governed by English law will be sort of structured and how they will be documented. But of course, that's session 6, international aspects of corporate transactions, which is where Chris Beanland will then pick up much more on cross-border acquisition. So I suppose 2 points there. One, yes, certainly as far as global is concerned, that's what we hope session 6 will deal with. And Alejandro, to pick up your point, we want these very much to be practical training sessions. Yeah.
Thank you, Claire. Anyone has another question? Thanks. Anyone else has another question? Well, I will put in the box. I guess it's pretty clear because we already sent the links of the website for the programs. But I will put right now the email address. The email address in the chat box for everybody interested in the programs. I will. So I just put the email for everybody interested in the programs. Just the only have to do is to email to this address, in-house-training.ec.uk, and for the registration. And we hope this session for all of you has been interesting, and we hope to see you again, all of you, in the International Business Law Program starting in October 21st. And lastly, I will thank again to the panelists, Rory, Claire, and Jim, for the really clear and useful session of today, covering all the main issues that will be covered deeply in the first program. And thank you very much. If you don't have any further question, we can finish the session.
Thank you, Alejandro. Thank you for hosting, and thank you to everybody for attending today.
So thank you very much to all of you.
Thank you.
I will see you soon in the programs. And I repeat, if for all the participants having any question about the program, just you have to email to the direction, the email address I just put in the chat box. And anyway, we will send to our participant the link for the website again for the program starting on October 21. And please, any question you have, please feel free to ask for any further question. We will please to answer any question you have. And thank you very much.
Thank you again.
Thank
Goodbye.
you. Good
Thank
night.
you.
And
night.
have a good evening, everybody.
Thank you very much.
Bye-bye.
And Jim.